medical practice. A healthcare practitioner may be a witness, and then there may be issues arising as regards subpoenas, witness fees and expenses, and the practitioner's credibility and reputation when called as a witness. Now, a subpoena is a formal document. It is an order from the court to attend proceedings. Sometimes there are tribunals too, which have the power to issue subpoenas to witnesses. It is very important to obey a subpoena because disobedience can lead to such serious proceedings as contempt of court proceedings. Now, from time to time, I've come across this issue. A doctor may say that when attending court for a case, that he must be paid the fees and expenses. The general principle in Malaysian law is that a doctor must be paid a reasonable sum for traveling to, remaining at, and returning from court. It is not the law that a witness is to be paid for, say, loss of earnings. Frequently enough, I have seen doctors claiming payment of money for by way of an issue regarding loss of earnings. Imagine if you have a billionaire as a witness, can you afford to pay that witness his or her loss of earnings for the day? So the idea is, the important point is that when you go to court as a witness, you are performing a duty in the cause of justice. It is about serving justice. Because all of us one day may need assistance from the system. And that is why it is very important that people cooperate. But yes, sometimes doctors and other healthcare practitioners may find that their actions, their words, what they say can get scrutinized in court. It does happen, even when the doctor is a witness. I'd like to give the example of Professor Sir Roy Meadows. The key words would be abuse of statistics. Professor Sir Roy Meadows was a consultant pediatrician known in the UK for developing this point regarding Munchausen syndrome by proxy. The words by proxy, therefore, are used so as to mean that the person causing harm intends to harm somebody else for the purpose of bringing attention to himself or herself. So this was Professor Roy Meadows' idea. Now, he came to the conclusion in a number of cases that there had been a series of deaths, say, in a family, and that those series of deaths were suspicious in nature, and that the mothers were to be blamed. So his point was something like this, to put it in a very crude form, that one death may be a tragedy. Two deaths would be seen as something very troubling or suspicious. And that if there were 3 deaths of babies in a family, then it must be something criminal. Now, he did not take into account such factors as genetic factors, environmental factors, social factors, family factors, which may affect a baby, that the next baby may suffer a same fate. So, well, what he did was in court, he was very emphatic about his point. The mothers ended up in prison. It took a lot of trouble. Eventually, the mothers were released from prison because it became very clear that Sir Roy had misled the court through improper use of statistics. So, disciplinary proceedings were begun against him, and it was an extremely complicated case. From the medical council, it went to the High Court and up to the Court of Appeal and back down again, up and down, up and down. Eventually, Professor Meadows escaped liability in a disciplinary respect. He removed himself from the register. You see, this is the curious and interesting point. If you are not on the register of medical practitioners, the General Medical Council cannot take action against you for misconduct. So that's what he did. So an important point made, although Professor Meadows escaped punishment, was that the Medical Council could take action against a doctor for misconduct as a witness. Now, generally, the courts would be protective of witnesses who come to court, that they should not face ill consequences. But there are some exceptions. The witness who lies can get charged in court for perjury. So the witness who commits, the expert witness here, who commits misconduct can therefore be found guilty by the medical council for misconduct. Yes. So a general point that healthcare practitioners owe duties to patients and their families, to the community, and to their profession and colleagues. It's like this, that a doctor is a member of the profession and also of the community. So if a doctor were to behave in such a way in public so as to bring shame to the profession, the medical council can take action. For instance, if say a doctor, by reason say of alcoholism, causes a terrible accident on the highway, not only would the doctor may be liable criminally, but also answerable to the medical council, because the doctor is seen as having brought shame to the profession. Doctors, of course, owe duties to their profession as well and to colleagues. From time to time, we have seen misconduct of this sort. For instance, this principle that no practitioner should obtain an unfair professional advantage over a colleague. So if there are some rules about, say, advertising, so a doctor should not advertise his or her services. Say, out of 190 of them follow the rules, say, but 10 of them advertise their services. Now, the 10 obtain an unfair advantage, while others follow the rules, and the 10 don't. And that's when the medical council may crack down upon the doctor. Now, of course, in recent years, there has been a loosening as regards restrictions against advertising and canvassing. Next. What are the common causes of medical legal problems? Administrative and clerical errors, organizational and system failures. We see examples of poor communication, inadequate or missing records. But I will add, sometimes excessive medical records can cause a problem. We have seen this, defensive writing of notes, defensive writing of medical reports. You know how much people blab, in trying to explain their actions when they are in trouble. Just imagine, ladies, when your husband comes back home in a, say, suspicious.
I object. This is a sexist remark. Go on.
I would like to be politically incorrect. Anyway, just imagine how much husbands try to explain things. They say too much. So sometimes we see this kind of problem. But another aspect, about medical records, trimming of medical records is vital. Otherwise, what you may find is important material, important information gets buried in a mass of detail, whether online or on paper. So it is very important to trim your records. Another issue can be about working beyond the level of competence. You'll be asking for trouble. Similarly, when you delegate to those who are below the necessary level of competence, that too can be a problem. And then insufficient clinical assessment of cases. May I give you what is probably my very first medical legal case? About 40 years ago. What happened was, there was this bank manager who phoned the bank's panel doctor to say that after a wild night, he felt that he needed protection against an infection. And he told the doctor, can you get me some antibiotics? And the doctor said, no problem, send your messenger. The doctor supplied sulfonamides, Bactrim or Septrin, as it is known sometimes. A few mistakes. First is, the doctor did not insist on the patient coming in and seeing him. So this was an early example of telemedicine, which went wrong. So he did not see the patient. He did not even look at the patient's records. He should have called for the records. Instead, he told his clinic nurse, get some Bactrim ready. The messenger will come and pick them up. So he did not look at the records. The records contained these words. Word, sulfonamide written in red. The patient was allergic to the very drug that the doctor intended to supply. I don't even call it prescription, I say supply. So that was another serious error. Giving it to the messenger, someone not known. So what happened was, when the bank manager swallowed the medicine, he suffered severe erythema multiforme, the Stevens-Johnson syndrome. So clearly, it was an avoidable accident. So he was ill for a few days. Immediately upon onset of the condition, he then went to the doctor's clinic and he was then treated for the reaction. Now, the doctor's duty of care continues. He had got done wrong already first. And when the patient presented himself, the doctor's duty of care continued. He had to try and get the patient better. The patient did get better. Later on, that patient, unsurprisingly, brought a claim in court, but it was dismissed. What had happened was, 19 days after the patient had taken the sulfonamide, he ended up in a big private hospital suffering from an asthma attack. His lawyers pleaded this as part of the claim, that as a result of the taking of sulfonamide, the patient suffered the asthma attack. Instead of pleading in court that it was the Stevens-Johnson syndrome, which was the damage. So a wrong framing of the claim. So interesting, negligence, but the claim got dismissed because of the lawyer's mistake. So lawyers can come to the rescue of a negligent doctor by acting for the patient. So I think that is an important point to make here, that there should be basic precautions which would have been followed there. You may wonder what part I had to play in that case. I was not the lawyer for the patient.
Thank God.
I was the lawyer for the doctor. Right. So please keep in mind, administrative and clerical errors and organizational and system failures are usually more difficult to defend than other types of errors and failures. So simple things like, having proper records, details of the patient, about, say, a duty roster. If you're running an ICU, that you should have enough nurses according to the ratio which has been set out by, say, high authority. Failing to follow these kind of, say, requirements will become more difficult to defend. What would be easier to defend? Errors of professional judgment. Every great football player, Ronaldo, doesn't always score a goal. Sometimes he misses. But that does not mean that he's a bad footballer. Michael Schumacher could not win every race. So, when it comes to matters of professional judgment, doctors have an easier time. You can reduce a great deal your medico-legal issues by making it a point to have a proper organization, proper system, and paying attention to administrative and clerical matters, because judges understand these kind of failures and errors when compared to errors of professional judgment. So, if, say, Mrs. Tan's X-ray film is filed with, say, Mrs. Tang's records, because somebody got mixed up between the name Tan and Tang. Two patients will suffer, Mrs. Tan and Mrs. Tang. But that is something which a judge can understand easily. You made an administrative error. You made a clerical error. So one case I came across years ago, a lady fell. She suffered a fracture at the ankle. That was very clear. The general practitioner who saw her ordered an X-ray film. So the lady went off to a radiological center, and X-ray films were taken and a report was produced, which showed a clear fracture. When the X-ray films and the report were sent to the general practitioner's clinic, a big mistake occurred. The nurse simply put them all away into the patient's file without bringing those documents before the doctor. So the result was that the patient was not informed that she had a fracture. She went on a trip to England, and there, when she found that she continued to have problems, she went to see a doctor and they discovered the problem. So she made a complaint. Now, interestingly, the case didn't go very far. What happened was that doctor did not try to bluff his way through. Just like I think many husbands should not bluff their way through when they go home late after an exciting night. So this doctor did not bluff his way through. What he did was, he prepared a letter of apology. And the patient accepted the apology and dropped the matter. But usually, you see, patients will drop the matter if they have not suffered much harm. If it is something truly catastrophic, it's very difficult for the patient to forgive the doctor. But my point is, if you have done wrong, don't try to bluff your way through. Apologize, explain, try to get the patient to improve in terms of the condition of the patient. All these things are vital. So now, when it comes to, say, errors of professional judgment, it is about, say, things like making a diagnosis. Nobody gets the diagnosis right the first time, right? Patient goes to Dr. A. The symptoms and signs are not very clear, say. Gets treated for, say, condition A. Goes to Dr. B because the patient is still not well. And gets, say, treatment for condition C. Then goes to Dr. D, who comes up with a correct, so-called correct diagnosis. So patients will say, the first two doctors were very stupid, but it may well be because the third doctor saw a much clearer clinical picture. Earlier treatment which had been offered had failed. So that third doctor had the advantage of seeing what had happened before. So these are, I think, very important points, to keep in mind about judgment. But there are, of course, errors of professional judgment which are difficult to defend. Sorry. Expert evidence, vital, especially as regards diagnosis and treatment. Now, as I've said, not all errors of professional judgment amount to negligence. And in the third bullet point, this point is made. An error of professional judgment amounts to negligence if it is an error which no professional person exercising due care and skill would have made in the circumstances. So in such a case, even though there was a so-called wrong, say, conclusion, the doctor can get, say, success at trial in regard to a claim for negligence. So now to go on to the types of claims. Claims in negligence, breach of contractual and statutory duties, which are becoming more common nowadays, battery. Let me explain about battery. You see, we have this law of tort developed in the common law by judges. At one time, there was no tort of negligence. There was the more ancient tort, battery, and intentional wrong. Then the judges decided to, stretch things further. That they saw that the tort of battery alone was not sufficient. That they had to develop the tort of negligence. You don't intend a bad result, but you were negligent, although you did not intend it. So they developed this concept that you owe a duty of care, and if your breach of the duty caused reasonably foreseeable damage, then you would be in trouble. Interesting, what is reasonably foreseeable? Not everything is reasonably foreseeable. Let me give an example, not connected with the law. About 50 years ago, a lady in Czechoslovakia decided to commit suicide because her husband had left her for another woman. She jumped off a building. She survived, her husband died. Guess who was that pedestrian on whom she landed? It was her husband. Now, you will say it was not reasonably foreseeable that she will land on her husband. But it was reasonably foreseeable that she will land on somebody, suppose. But so, we have to see what is reasonably foreseeable. The moral of the story for men is when you walk down a street, look up once in a while. Your wife might give you a surprise. Now, against the second bullet point, I have these words, statutory duties. We see that more often nowadays. Now we have got this private healthcare law. It runs to many pages. On practically every page, there is an offense mentioned about various things. You must have a telephone for the use of patients in your place of practice. That's one example. There's something about the width of doors, windows, about facilities for emergency and all these things. You break those rules, you're guilty of a criminal offense. So you can get into trouble. And there is this new thought now. Negligence used to be the thought, the flavor of the times. Now, especially in England, they bring in this breach of statutory duty. Because the legislation provides for something regarding patient safety, and if the doctor or dentist or whoever acts in breach of that statutory duty, it becomes a wrong for which the doctor or dentist or other healthcare professional has to pay to the patient. And of course, doctors and patients may make contracts with each other. The contract may have something very specific. Now, it has been said, in one of the leading textbooks that doctors belong to a profession in which there is no undertaking to produce a desired result. Don't guarantee results, right? Lawyers too don't guarantee results. You should be suspicious of the lawyer who can tell you in regard to your court case that he or she can guarantee the result. So, since doctors do not guarantee the result, the test to apply is whether the doctor has exercised due care, skill, and diligence in seeking to arrive at the desired result. But you can't apply that in commercial bargains. You borrow money from the bank, you can't say, I will exercise due care and skill in trying to return the money. That's not good enough. You repay. You don't pay, no excuses. So, similarly, if you buy a house from somebody, in the sale and purchase agreement, there may be something about making payment of the balance sum on a later date. You pay a deposit first. You cannot say, I will try my best to pay the balance sum. You undertake to produce the desired result, payment of the balance sum. So in contract, when it comes to commercial bargains, there is an intention to create a desired result. So doctors, hospitals, they all have to be careful about what they tell patients they want to produce. So there was this dentist who got into trouble. And I think I mentioned his fate in one of the later slides, but I might as well tell you now. A dentist got into trouble because the court came to the conclusion that he had entered into a contractual bargain with the patient to fit a denture which would fit the patient's jaw. And the denture did not fit the jaw. So, breach of contract, don't have to show due care, skill, etc. The dentist can say, no, I exercise due care and skill in trying to fit the denture. The court's position was, no, you undertook to give him a denture which would fit. So this kind of difficulties can arise. Let me give an example of how lawyers try to argue it. But blood is the giving of blood, the sale of a product, or is it seen as the provision of professional services? You see, in the courts, as a general point, it is easier to sue for a defective product than to sue for professional services which fail. Because when it comes to professional services, what does the professional person say? I will exercise due care and skill in seeking to produce the desired result. But when it's come to say sale of a product, the person selling the product says, I undertake to produce, to sell to you a product which is fit for its purpose, which is of good quality. So it's not about trying. So there can be this difficulty. So when it came to blood, though, interesting, lawyers were trying to argue, lawyers acting for the patients were trying to argue that contaminated blood should be seen as a case of delivery of defective goods. That point, I think, failed in Australia, but succeeded in Canada. Judges have different views, you have to think, when people ask me questions that ask, which country are you living in? So they came to different conclusions. So that's something to think about. Now, there are also the other types of claims, breach of confidence, misuse of confidential patient information, for instance. There have been a number of dramatic examples in Singapore. One particularly interesting one was of a gay couple, one of whom was the so-called wife. The husband was an American gentleman who got into trouble with the immigration authorities because the so-called wife, I think, had provided his specimens for screening for HIV. The so-called husband, that foreigner, was HIV positive. And if he was HIV positive, he could not get a work pass in Singapore. He could not live in Singapore. So a false set of information was given to the immigration authorities. Eventually, that fraud was discovered. So the so-called husband, or shall I say husband? Why this cumbersome expression, so-called? The husband ended up in prison and he was to be deported. So he was deported. He wanted his wife to be free. The authorities were going after the wife, that doctor. What did the wife do? Steal confidential patient information and passed them to the husband, who was safely in America. That's what he thought. You're safe there. And then from the safety of America, as he saw it, he threatened the government of Singapore, that little country there, free my wife, or I will spill all this confidential information about patients to the public. He carried out his threat. The government of Singapore did not back down. That wife is now, I think he's gone to prison already. I'm not sure. But I know, last I heard, he was going in and out of court. What did the government of Singapore do? They reported it to the American authorities, right down to the state and county level. And they went after that husband, and he got clapped into irons and sent into prison. See the kind of complication can arise. So in Singapore, the unlawful taking out of confidential information led to a flood of legal issues. System failures, someone not authorized to get access to the information, all these things arise. Sometimes the most trusted of people break the rules. So sometimes you may have this note, you have to think about, is there a red flag about somebody? maybe about that person's behavior, about that person's financial problems, about that person's relationships, that a well-behaved person can come under the control of somebody unscrupulous. So those kind of problems can arise. Right? Now, of course, next one is loss of or damage to patient's belongings. Yes, from time to time, patients complain, but sometimes something more sinister. This expression, undue influence, it has been used in the law of contract. Say, like if a patient makes a gift to a doctor while under the undue influence of the doctor, that transaction can get set aside in court. Sometimes there can be defamation of a patient. I came across a case once where a young unmarried Muslim woman was wrongly described to others as being pregnant, which suggested that she had engaged in zina, illicit intercourse. It was not a case of a virgin pregnancy. So she got into difficulties. It was a case of defamation. I have to move faster, I think. Let me tell you about the Bolam test. It's actually a defense. The defense would be if the doctor had acted according to the standard of the ordinary competent doctor. So this is where expert evidence becomes relevant. However, in recent times, there has been erosion of the Bolam defense. Next one. When it comes to the giving of advice and information to patients, especially regarding warning of material risks of treatment, Bolam does not apply in Malaysia anymore, and also in a number of other countries. I emphasize these words, material risk. The duty is not to warn of every risk. You might frighten the patient. It is a risk which the reasonable patient, or in a particular case, the particular patient would want to know. There's been a shift from the doctor standard to the patient standard when it comes to disclosure of advice and information. So materiality is measured by reference to a patient standard. And then we have the Bolaitho qualification to Bolam. So if an expert comes along to court to defend the actions of a doctor, the court can reject the expert's opinion in defense if it is not reasonable, not responsible, not respectable, or is without a logical basis. So that is a vital point. Now, in our Evidence Act, there is provision. The grounds for an expert's opinion are always relevant. The facts supporting or not supporting an expert's opinion are also relevant. So, at this stage, I make this conclusion. The Bolam-Bolaitho defense is not relevant to administrative and clerical errors and organizational and system failures. Why? Because the exercise of professional skill is not really any point there. Duties set by contract or statute. Look at Malaysian private healthcare legislation. So, and the next one is about supply of defective products. So, Bolam-Bolaitho is really as regards judgment, professional judgment. And so the courts have been taking a stricter view as regards matters of professional judgment. Now let's look at some examples about things going wrong. In Singapore, the general practitioner asked a patient embarrassing questions. First of all, they were not relevant. So you have to be careful, right? 18-year-old girl treating her for URTI, and he asked her personal questions. So he got into trouble. Next. Oh, this doesn't look good. doctors being used for a commercial purpose. Next one. The surgeon who lied, he claimed that his sister was killed in the September 11 terrorist attacks. Not very clever, I think. And this one, in Singapore again, doctors not having practice certificates and they get into trouble. Now, this one, what did the doctor know? Under Malaysian law, carrying out an abortion is a criminal offense. Right? No. Okay. So, the lady's boyfriend lodged a police report because the doctor threatened him. Now, he was asking for payment for a criminal offense committed by himself. He was asking for trouble, and then the doctor lodged a police report. He was inviting trouble for himself. The wrong side. See, when there's symmetrical anatomy, there can be a problem. If, say, the OT staff and the, say, ward staff do not coordinate things, trouble can arise. So, somebody is looking at it, say, the wrong way around. Another is possibly, say, the ward manager, the nursing manager sends down patient number 2, and the team in the OT think that they're dealing with patient number 1. So here, you can see the pin and the plate were inserted in the wrong hip. Difficult to defend. But don't let your accounts department be too efficient. Right? So, what happened here? That both upset when the doctor amputated the wrong leg, but the patient decided to sue only after the doctor sent him a bill. Billing for your mistake? Unacceptable. By the way, not too long ago, we had a case in Malaysia of a lawyer who underwent surgery performed by an endocrinal surgeon. An adrenal gland, which was diseased, had to be removed. He removed the other gland, which was healthy. Wrong side surgery. And then they had to remove the diseased gland. So she ended up with no adrenal glands. So she had been condemned to a life of frequent medical treatment and consultations and suffering. A huge amount was paid out in settlement. Next one. How about this? 2 patients with the same name. And you see this, the wrong patient underwent a hysterectomy. Can you imagine? In a busy clinic, the nurse comes out and shouts, Subramaniam. And there are 3 of them, say. One is busy on the phone outside. One is in the toilet, and the wrong Subramaniam stands up and goes in. Or the nurse says, Hamida binti Ahmad. And Hamida binti Muhammad steps forward. Those kind of things happen. By the way, when the patient, is about to undergo surgery, has been, given pre-op drugs and all that, and then you ask questions like, are you Mrs. Tan Ah Kow? When you put it like that, leading question, the patient's answer will be yes. Dangerous. When says maybe Mrs. Lim Ah Kow. So these kind of problems arise. These are easily avoidable problems. So, mishearing. During the Second World War, surgeon said on the telephone, cocaine. House officer heard cocaine. So, house officer wrote the prescription. Now, under their system, a pharmacist cannot supply cocaine on a prescription written by a house officer. So the system was not followed. So the patient died a happy death. Difficult to defend. Next one, please. And how about this? Leaving your hardware behind. So simple things like arranging your instruments, counting them. We once had a case in Malaysia. Not one pair of forceps left behind, 2 pairs. I mean, in the OT, did the surgeon and the nurses wonder, where are these 2 pairs of forceps? Where are they? Did they think they were disposable items? So it's difficult to defend this kind of thing. So what about this one? There was this ancient professor of obstetrics and gynecology. He had this case of a retained swab. Patient came back after delivery of her baby, and after having gone home, she came back and complained, I found this in my vagina, and she had brought it along to show it to the professor. And he said to her, who told you to take it out? And he put in a fresh one and told her to come back for another appointment. Nowadays, you can't fool patients that way. Right? Because patients know better now. But it worked at that time. I would say not anymore. Next one. Make sure that your instruments are complete. Look at that butterfly screw. The Medical Defense Union reported it. That it slipped off a retractor. It was something that the surgical crew could have detected. Not done. So, some people don't know how to spell. He didn't know how to spell acute, so he did not write it down. Can you imagine acute, say, myocardial infarction, and you don't write acute? Acute bronchitis, or chronic bronchitis. And it went before a coroner. He had a difficult time. It goes on in Malaysia, by the way. No, about misspelling. Look at this one next. The pen is mightier than the sword. Doctor wrote isodil, or rather he intended it to be read as isodil. The pharmacist read it as Plantil. Now, surely the pharmacist should have been a bit suspicious. No? First of all, bad handwriting. Secondly, Plantil is not supplied in 20 milligram doses, to my understanding, not in Malaysia anyway. So you should have checked. There was a case in the UK, a doctor wrote amoxil 250 milligrams, but he wrote it so badly, the pharmacist read it as Deonil 5 milligrams. It was a case where the pharmacist should have checked the prescription. The pharmacist was found 75% liable, and the doctor was found 25% liable for his bad handwriting. There was a lawyer once, he got into trouble with the judge. He wrote that the learned magistrate in an appeal had convicted his client on abominable evidence. The judge asked, what is this abominable evidence? It looks like the lawyer wrote inadmissible evidence. And the secretary couldn't understand. She thought it was abominable. The lawyer got a scolding from the judge, but still managed to win the case. So miracles can happen. Next one, please. Intel, and it was misread as Indira, a beta blocker which the patient did not need. Next one, please. Look at the alphabets: A, B, C, D, E, F, G, H. Then he goes to N, O, P, no Q, S, T, U, V. What is he trying to say? Can you imagine if your colleague writes that and you're trying to figure out what is this all about? Airway, breathing. So this is not the way to write notes, especially if somebody else is going to read your notes. Next one, please. Tampering, late entry. If you see there, the details. Look at the next one. Actually, originally, this was all that was written. Go back to the previous one, we'll see. You see, after the event, he wrote, and he didn't mention late entry. He realized something had gone wrong and he wrote extra. That's why, when doctors get into trouble, they tend to talk too much and write too much. Next one. They carry on a quarrel. Can you see it's a bit faded, rubbish. That's a diagnosis, hypoglycemia. Somebody wrote rubbish. I don't need your professional inverted advice. Don't carry on a war like that in the notes. It's not good. Does not reflect well on the profession. It makes patients anxious. Next one. Is this how you describe something which had gone wrong? Little finger bucket. But which one? They don't even tell which side. This is not a proper description. Is it a dislocation? Is it a fracture? Is it a contusion? Not properly described. Next one. Work undertaken by a general practitioner, not properly qualified. So here was a general practitioner who practiced again above his level. It's difficult to defend. The next one, liposuction, again by a general practitioner, not properly qualified. He had practiced above his level. By the way, talking about above your level and below your level, I have this question about breech deliveries. Midwives are not allowed to undertake surgery. Obstetricians and gynecologists and say doctors with no higher qualification, when they see a breech presentation, they may opt for a cesarean section. But a midwife, when confronted with such a situation, may manage a vaginal delivery, say. So, is breech delivery becoming a dying art amongst doctors, especially obstetricians, when compared to, say, amongst midwives? Something to think about. One of the earliest cases of separation of conjoined twins in this country involved conjoined twins who were delivered by a midwife in Ipoh. Just under the law, a midwife can operate a maternity home, but she must have medical supervision. But when the event occurred, there was no time to call for a doctor, but she managed to get the two little babies out. Next one. Forgetfulness. I spelled it wrongly. Ingrown, not ingrain. I think this must be autocorrect. See, I blame others, easily. But you can make out right what I mean. So the tip of a rubber glove was improvised as a tourniquet. After the procedure, the toenail having been removed, that improvised tourniquet was not removed. So ischemic trouble arose. The patient lost a big toe. Again, an ischemic problem, tight POP. There were warning signs and symptoms. At the beginning, it may be about, say, pain. It may be about swelling. And later on, say, the toes may be cold. The patient's unable to move the toes. That may be quite advanced already. The easiest thing to do would be to split the POP, not acted upon. And see, this is the final result. Next one now. Next one. Inadequate assessment. Look at it. Something flies into his eye. He was hammering. So, the treatment given, an eye ointment following examination. Insufficient assessment. The doctor should have been on guard. X-ray film showed a metal piece. And upon using the ophthalmoscope, this was what was seen. The final result was a blind eye. But there was a consultant ophthalmologist who told me, though, that the metal piece was so big, removal without delay of that piece would not have helped save the eye. So causation becomes an important point. Even if, say, everything was done right, the final result may have been blindness in the eye. But the doctor could have got into trouble with the medical council for misconduct, for not undertaking proper assessment of the case. But I don't know if that is the case, so that the final result was inevitable, then the doctor would escape liability in a negligence action. So there was a case of poisoning in the UK many years ago, and there was delay in attending to the patients who had arrived at a hospital's accident and emergency department. Delay. And one of them died eventually. But the court came to the conclusion that there was negligence in regard to the delay, but that even if the patient had been seen and treated without delay, he would still have died. He was a gone case by the time he arrived at the hospital. But clearly there was misconduct on the part of the doctor concerned for not attending to a serious case. It was an emergency. So I'll say this, at this stage, I'm coming to the end of my presentation. There should be this common object, patient safety. I would say that there's a need to move away from an adversarial relationship. And I think, lawyers have to also think about how they think. There was a joke made by a doctor once at a dinner event. He was a speaker. And he said, once in a small town, there's only one lawyer and he had no business. Soon later, sometime later, another lawyer set up business. And soon the two of them became very busy because they were fighting each other in court. Now, there's a need to shift away, as I said, to focus more on patient safety instead. Lawyers should not think that they have to be like gladiators, each time when they're asked to look at a case, that they have to go to war. In fact, the rules of the legal profession do say that lawyers should act with courtesy, candor, fairness, not to harass people, not to intimidate people. Sounds very honorable, right? Have you seen such a lawyer? Such a lawyer, an honorable person. Why do you think lawyers wear wigs? I mean, they used to at one time in Malaysia, because it was said that at one time, gentlemen wore wigs. Today, the only gentlemen left are lawyers. Well, you won't believe me, of course. So, are all the stakeholders ready for this shift? I think we need to look at ourselves. Let us not always go to war. Right? But one point I would like to make also about the commercialization of healthcare. It has, I think, also made patients think differently. In the 1950s, when a doctor walked into the Kuala Lumpur General Hospital, the patients would struggle to their feet. They had so much of respect for doctors. And if you look at the old English cases about medical negligence, I sensed this thinking of judges that if healthcare is delivered by a charity, by a non-profit organization, by a church group or something like that, that the courts should be less, particular about accidents which happen. So there's some kind of, as I said, charitable immunity. And now when you get great corporations, talking about how they're delivering fine healthcare, the highest standards, boastful website details. What are they saying? They're raising patients' expectations. So this has led to difficulty, I say. Next one, please. So, but being a good Samaritan is no defense. So this is doctor in Australia who got into trouble because he was trying to ascertain the patient's intraocular pressure, applied a hot tonometer, and the patient suffered injury to the eye. Next one. So, how do you avoid medical legal problems? I think it is important to organize properly the delivery of healthcare. And then have and follow proper systems. Practice good and courteous communication with patients and colleagues. Keep at a reasonable level patients' expectations. Write and keep proper medical records. By the way, the law of limitation in Malaysia is extremely complex. Limitations vary from one case to another. The limitation period can be as short as 3 years. It can be as long as 30 years in many cases. In some cases, the limitation period does not expire at all while the patient is alive. I'm afraid giving details about the law of limitations beyond the scope of this presentation today. So it's very important to have some, say, system as regards the keeping of proper medical records for a sufficient period of time. Practice at the appropriate level. Next one. Delegate tasks only to the competent. Undertake sufficient clinical assessment of cases. I'm not saying you should overdo it. Defensive medicine, where you do everything, is bad medicine because it causes a shift in focus from care and concern for the patient to care and concern for the doctor's own interest. That's not right. Be compassionate. I would like to recount an event which took place in 1964. Somebody wrote a letter to the newspaper complaining about the conduct of a nurse in a hospital. What had happened was the writer of the letter had visited the patient in that ward where the nurse was on duty. An elderly Indian lady came along to visit her husband. She did not know he had died the night before. So she stood there at the empty bed. The nurse called out from her station, "Awak punya laki sudah mati, pergi cari dalam mortuary." Translation for those who are in another country and don't understand the language: your husband is dead, go and look for him in the mortuary. It was a cruel way of putting such sad news to that lady. She just collapsed into a heap and wept. Avoid making rash remarks about patient care and management. I think be very careful about that. There was a dentist once made a remark about his management and got into difficulty for a while. He undertook surgical drainage of an abscess. So he had to remove a wisdom tooth. Having removed the tooth and having effected drainage of the abscess, he looked at the tooth and said to the patient, "It looks sound." The patient asked for the tooth and went to see a lawyer. Now, of course, there was a misunderstanding. The tooth had to be removed, although it was sound, because there was this abscess which needed to be treated. But you see how even an innocent remark can get misunderstood. In Singapore, some years ago, a neurosurgeon told the father of a boy, "I'm sorry, your son is brain dead." The father replied, "Oh, there's still hope then." You see, they misunderstand. So, be prepared to give opinions to patients in medical legal cases. Why do I say that? In many a case, you'll be able to reassure the patient that the doctor concerned had acted correctly. And then the patient may close the book and move on. And if in fact there is negligence, then the patient can seek justice. When patients see that doctors are blocking them from getting justice, it breeds resentment amongst patients. Finally, have a simple and effective complaints procedure. I must commend the government of Malaysia for, I would say, doing more and more nowadays about complaints. But I have this point to make. Don't make it too complicated. In some situations, there may not be a need to have a committee of inquiry. It may just need the head of department say going and telling the lady, I'm sorry, madam, that we left this swab inside you. We are very sorry about it. It should not have happened. We apologize. Not called, say, half a dozen, consultants from various places to sit and decide on the issue. Thank you. Now, ladies and gentlemen, that sums up my presentation. I believe, Dr. Tay, that there is some time for questions.
Yes, I think it's been a very eye-opening talk. I think that as an excellent lawyer you may be, you would make a very good stand-up comedian. You are quite funny. And I would also say your knowledge about the medical presentation and description put some of our doctors to shame. So we do have one question. Serene asks, what are the definition of meaning of contractual and statutory duties respectively?
I'm going to give an answer which may not really explain anything. A contractual duty is one made by contract. The parties get into a bargain. So the doctor says, I will amputate your leg. The patient says, all right, I agree. I will pay you for it. The doctor says, fine, this is my fee. So there's a contractual bargain. A statutory duty is one created by legislation. It could be by parliament. It could be by an authority which is subordinate to parliament, like say the Malaysian Medical Council. So they make regulations. By the way, not every regulation made by the Minister of Health is valid, but that it will take me half a day to tell you why I say so. I mean, having said that they're not valid, I'll explain, but there'll be a lot of arguments. I don't agree with some of the regulations which have been made. I think they are invalid. Next one.
Okay, Ruben has a question. He has raised his hand. Ruben, will you like? Okay.
Hello, can you hear me?
Yes.
Can you tell,
Yeah,
are you a doctor or a lawyer?
Yeah, I'm a doctor, medical doctor, having my own GP practice. I'm from Kluang, Johor. I'm currently doing my medical law and healthcare in Taylor's University. So I have a question. Okay, so now in this pandemic case, COVID, all right, is there any rule telling that the patient, the doctor can refuse treating the patient because of the COVID, because it might affect me or my family and everything? Is there anything, any rule or anything that saying that I can refuse treating the patient? And if there is such rule and everything, are there cases in Malaysia to tell that doctors can refuse to treat a patient because of the issues of like COVID-19 and things like that?
So I'll answer the question with a question. Why do you become a doctor?
I know it's an ethics involved and everything, but
First of all, I think the duty is to treat the sick, to comfort them, etc., right?
Correct.
So if a doctor has to treat a patient where the doctor may get exposed, the duty cast upon the doctor is to take reasonable measures against, say, such harm occurring. There is that, but keep in mind, there is this unequal relationship, doctor and patient. I am not aware of any explicit rule of law that a doctor can refuse. Now, especially in an emergency.
Understand.
Now, if it is something elective, the doctors will say, as a matter of conscience, I will not undertake the termination of a pregnancy, even though it is allowed by law. Because he may say, my church does not agree to termination of a pregnancy in such circumstances.
Mhm.
It may be something which is elective in nature.
Understand.
There are others who may be able to undertake it. Now, what I would say is it certainly be an extreme measure to refuse to treat a patient who is in need. You must be ready to justify your position. Can you do it?
Yeah, that is a bit tough. No, I'm asking this because of my master's. You know, this is the question which came up in my master's degree and my master's question, that can we actually refuse a patient? Whereby in practical, I know I cannot refuse any patient, but can we refuse a patient?
As
And
in
what are the
lawfully,
consequences?
lawfully.
Lawfully, yes, lawfully. Can we refuse a patient lawfully?
So I think if you going to look at an act, then I'm not sure if Mr. Ranjan, where are you?
I'm here, sorry.
Okay,
Uh-uh.
okay.
No, my point, I think I made this point. First of all, if you refuse, would you be able to justify it?
Understand?
You know, all of us expose ourselves, right? Next,
Correct.
what will an airline pilot say? What will a bus driver say? I'm afraid, of crashing into a parked car around the corner.
Correct.
All of us take risks. The surgeon who doesn't have complications is the one who doesn't operate.
Understand.
The forensic pathologist is always right, but always too late.
Not in my case. Okay,
I
so
draw a
Geraldine
distinction between
asked,
forensic pathologist and clinical pathologist.
oh, okay, sorry. Okay,
Uh,
so can you read the question? Can you see the questions on the chat? Do you envisage any change of the law or clamp down regarding doctors advertising on social media, as it is so common these days that the patient have come to expect it? Is
answer
that,
is,
yeah,
the answer is no.
yeah,
You know why? I say that in this country, everybody wants to have an audience, even those who make the rules. So I don't expect people say, coming down upon this. Yes, I see this. I believe that there is abuse of social media, abuse of the print media, abuse generally as regards matters of publicity. And such things can harm patient care. The public can suffer as a result.
okay. Serene, for the dentist case that you mentioned, would the dentist be not guilty if he has informed the patient in the first place that the dentures may be loose? Yeah, I wanted to ask you, how did this doctor and this patient sign a contractual agreement?
No. First of all, a contract need not be in writing.
I see, okay.
That this is the bad influence of lawyers. They think everything must be in writing. Huh? We have oral examinations, we have oral presentations, we have oral sex. Why not oral agreements? Oral sex. Well, there's somebody who thought oral sex is when you talk about it.
Okay, let's get serious here. Because
would the dentist be not guilty if he has informed? See, there, my point is, the court came to the conclusion that the dentist had given an undertaking that the denture would fit. Had given that undertaking, and it was a contractual undertaking, so he got into trouble. Don't guarantee good results. But how are you going to deal with your patients, every patient? You might drop dead, the treatment may not work. You say all these negative things. Then the patient will say, why am I going to this dentist? Why am I going to this doctor?
it is very difficult because especially in the private practice, even though we don't promise the world or a miracle, But to speak of such negativity is difficult. Okay, Miss Dr. Sauri Rajan says
Sorry?
we have many expatriate doctors working in Malaysia at all levels. If they have an annual practicing cert, are they free to carry out all duties of a practicing doctor and appear in court to defend a negligence? I should think so, right?
Wait. All due. Well, when you are on the register and you have an annual practice certificate, yes, you're entitled to practice as a doctor. Also, and appear in court to defend, you mean as an expert?
No, I think,
But as an expert or what?
okay, I'm not sure.
I don't follow, you know.
Yeah. Dr. Turai, okay, Serene asked whether digital medical records is acceptable in court.
Yes.
Yes. So, Bupi Daliwal, sorry if I pronounced your name wrongly. For how long do we keep patients' medical records?
Oh my. Please don't follow the income tax rule. It's not much help. I am not here to publicize my firm, but I think in the interest of time, please look at my firm's website. I was told today, I was reminded rather, that we have an article on our website regarding preservation of medical records.
Archiving?
Pardon?
Archiving of medical records?
No, preservation of medical
Okay.
records. I caution you, it makes heavy reading. You'll feel very discontented at the end of it. By the way, 7 years is very often too short a period.
Dr. Turai asked, he's a surgeon and he'd like to know if in the current pandemic situation, patients' conditions worsen waiting for delayed elective surgery, such as a degenerative spine, would it be negligence on the surgeon's side?
Well, surely like, triaging, you give priority to certain cases. Here we are in a very dire situation. Certainly, we have to take into account the circumstances. And therefore, it is quite clear while we are dealing with this pandemic, other patients who do not suffer from this coronavirus infection may therefore suffer as a result. Now, they suffer not because of negligence, but because of circumstances. Shall we say, act of God? It's a pandemic, an act of God. But this, certainly, I, as a lawyer, would say that if treatment for an elective case is delayed by reason of priority being given to the pandemic, then that would be a good ground to raise if an allegation of negligence is made.
Okay, Dr. Ko asks, you mentioned about adequate assessment and documentation. Sometimes it's not good to be detailed in our documentation, might be taken as our own personal judgment on certain cases as assault. How detailed shall we write? Oh,
I think the guiding principle is, when you write your notes, is for management of the case from a clinical perspective. It is not for you to decide, like a judge, this person is guilty of an offense. So if you see someone sitting in front of you and you suspect child abuse, under the law, you have a duty to report suspected cases of child abuse. So you may have to write in your notes. So similarly, if someone else has been assaulted, if that person says, oh, I fell down the stairs, but say upon questioning and upon say having looked at the clinical evidence, you think it is something else, you don't have to form a judgment as regards guilt. You can say like query, assault, Yes.
Dharmendra asks, as an inpatient seeking discharge on his or her own risk from hospital for a particular condition that needs treatment, from a legal perspective, is the patient signs the document stating refusal of treatment sufficient? Is there more documentation that is required?
Now, I have come across these AOR documents, at own risk, or DAMA, no? Discharged against medical advice.
Okay, hold on. Can
I
you
have come
put that-
across these, but I would say in quite a number of cases, the documentation was insufficient and insufficient advice had been given to patients. I think what is vital is not about acting like as though you have to, write in a legal way. If a patient wishes to leave, although that patient needs treatment, then I think you have to write in your notes, patient has decided not to undergo this necessary treatment. Patient has been advised. Yes, and you have to warn the patient of the risk of going out from the hospital. Sometimes patients may not appreciate it sufficiently. This thing about signing of documents, I'll be the first to say, don't always accept that something written is therefore the truth. I don't accept that.
Okay, that brings us to the other question that Karia has asked. So sometimes when it comes to oral contracts, sometimes misunderstanding occur. It's obvious, in which doctors have explained the risk of a procedure to their best, but patient may not fully understand or misunderstood the message. If this conflict arises, then is your word against mine?
Right. Let me say this, oral evidence is still evidence. Something written is not necessarily good evidence. There is this thinking, in this country that written stuff ranks above oral stuff. So, in our penal code, there is this offense of rape. Sexual intercourse with a woman without her consent. How many women give their consent in writing? Huh? No, please think about that.
Okay. I have a few questions.
Sorry, yes, go on, please.
Okay. So the first case that you spoke about, the asthma case, where the patient tried to sue the doctor, but because they stated that the complication that was brought about was actually asthma and not Stephen Johnson, okay, they lost the case. Now, in most cases where we buy indemnity insurance, do the doctor have a say in their choice of lawyers?
Well, my understanding is that medical defense organizations and insurance companies will have their panel lawyers. And it will be a matter for the defense organization or insurance company concerned about the lawyer to appoint. If there is an exceptional situation, maybe the defense organization or the insurance company would appoint another lawyer. In fact, many years ago, I think about 35 years ago, I was engaged by a certain institution, even though my firm was not on its panel of lawyers. It was on the recommendation of a law firm, which was on the panel, that I was engaged to provide my services. So clients, institutional clients have their discretion. I'll put it that way.
Yes, but most times if the doctors don't get to the lawyers that they are comfortable with, it could be a problem, especially when the lawyers do not exercise care, skills, or competence?
But I'll put it this way. I'm not here to judge my fellow lawyers. So I don't think this
Okay,
forum
I'll
is
go
the
on.
place for me to say.
Okay. I go on to another question, which is it a common practice these days where if a patient is to sue a doctor, for example, a general practitioner, is it a common practice to sue his premise, where he's practicing, the GP clinic?
You know, too often I've seen this, claims being filed against buildings, which is wrong in law. You see, suppose you suffer a fall at KL Central. You don't sue KL Central railway station. You sue the railway authority which owns and manages the station. That is important. By the way, sometimes inanimate things, like as I said, companies, they can be sued, charities, they can be sued. The Bishop of Kuala Lumpur can be sued. In India, this has been established even all the way up to the Privy Council, that the statue of a Hindu god has got legal personality. So there's this famous case in California in the 1960s. The statue of the Hindu god, Nataraja, had been stolen from a temple in India, finally ended up in the possession of an art collector in California. The government of India brought proceedings in the courts in California in the name of the god, Nataraja. Very, can be very intimidating, The god Nataraja against his art collector. By the way, they handed back the statue,
Okay. Anyway.
So the statue had legal personality.
So it has been a very, very interesting topic and a very interesting speaker. You made it very, very interesting. Thank you very much. We had a very, very good attendance. Almost 100 people attended this session. I think most are doctors. Okay. With that, I want to say and apologize for one thing. I was late in recording your webinar. So I recorded it a little about maybe the 5th slide. I'm sorry about it. And please don't sue me.
By the way,
Oh,
I becoming a stand-up comedian, my wife warned me. It's a very stressful occupation. What if the audience doesn't laugh?
okay. So if you guys did laugh at any moment, please just raise your hands so that we know whether Mr. B.S. Ranjan can make a change in career. Oh, we are seeing a lot of shift in hand. Well done, Mr. Ranjan.
See,
Please.
I want to give up the law. I want to give up the law and become a stand-up comedian. You can put me out.
Yes, you can, you can. You look at the numbers of people agreeing to that.
So if you avoid medical legal problems, there won't be business for me. That's how I see it.
Yes, we will try our best. We'll try and our best to be empathetic to patients, give due care and work within our skill.
But actually, I want to move into another field, celebrity divorce. I'll advise the women how to establish a high spending pattern without alerting the husband.
And then not falling on the husband when they commit suicide or attempt suicide. Okay, so Ruben has a question, I think. Ruben, did you actually lift up your hand to say that Mr. Ranjan can go into
yeah, stand-up comedian.
Yes, okay. So it was not to question anything, right?
But
yeah, no, I do have a question. Earlier, when we took indemnity insurance, they asked to take it on the doctor as well on my clinic. So earlier, Mr. Ranjan was saying actually it's wrong to take it on the on the building, but in future, will I face any issues if I don't take it on the clinic itself?
Let me put it this way. There may be a company which owns the business. That company is a legal entity. The building is not.
The company meaning the clinic, is it?
No, the limited liability company, say, which may own the clinic. You don't sue signboards, you don't sue buildings.
Mm-hmm. Understand. Because normally if any legal issues coming between patient and doctor, they will sue the doctor.
And the signboard. I've seen that. They sue the signboard.
Oh, okay.
I remember I saw one case, where a doctor came to see me and he was not named. His signboard was named. I said, you just lie low. You have not been named. Only the signboard has been named. So you won't get into any trouble because that signboard is not a legal person.
Any link attendant to fill up? No, there's no link attendant to fill up. Are you a nurse? If you are a nurse, you can message me and I'll tell you how to get your CPD points. There is no CPD points for this, okay? It is something that you don't need CPD points for because it is a talk that is meant to save your career and reputation. So don't bother about CPD points. Okay, good. I think we will get you back for another session. It's been, yes. I mean,
what should I talk about?
Oh yeah, maybe you can talk about, I'm not sure, but because maybe the next time we invite you back, you'll be speaking to us how you did the switch from a lawyer to a stand-up comedian. Okay, bye guys.
All right.
Great.
Thank you.
Talk. Hey,
Thank you. You've been a great audience. Thank you.
Oh, well done, Mr. Ranjan. I love it. You're very funny.
Thank you. Thank you so much.
Informative.
Pleasure.
Very, very. I love it. I love it. Can we have a copy of the slides? Okay. Can
Yes.
we? Yes, can. So, Mr. Ranjan, you can provide me the PDF of the
Yes.
slides. Yeah.
Also, Dave, by PDF, you can email it to what?
To me. You have my email address
Yes.
for all the wrong reasons. But don't forget me and my wrong reasons. Don't forget me. Especially if you want to do celebrity divorces. Okay.
All right. Thank you.
Very good. You can go home now. Can you share more cases? Okay. So some people have suggested. Okay. Nazira says, okay, all the nurses, please message me privately. Okay. So can you share? So somebody asked you to share more cases during the next session. Yeah. So maybe we can.
But the guilty will not be identified. All right.
Yes, the guilty. Well, you can, if they are guilty, why not identify? Yes. If you're not guilty, then we cannot identify you. But if you're guilty, well, we can show you how to identify them. Okay. Zai, can you just message me? All the nurses, please message me at the site, okay? Let's forget about CPD points first. Message me at the site. Okay, good. And they're still here. 49 people are still here. Oh, so, okay, we will definitely get you back. I need to find a slot because I'm really full until maybe December. Yeah, December is good. But we'll see you then. Bye, Mr. Ranjan.
All right.
Thank you so much.
Pleasure.